Yes, Mr. Collingwood.
My lords, if I may start where I think matters were perhaps leaving off before she was adjourned. And my own friend was speaking of all the uncertainty about pricing and which shifting values may affect interests. The whole point of a preference share is protection on the return from that investment. And that's firstly in terms of downside protection, and one has that under Article 5, 1 and 6 in terms of the priority and the cumulative 8% return. So that's your minimum downside protection. And secondly, in the upside opportunity, and that comes under Article 9.1 in the entitlement to convert where equity outstrips dividend. So in the ordinary case, a preference share is always going to be more valuable than an ordinary share, because it's always going to either have the benefit of the downside protection or be convertible to be the same as an ordinary share.
So just to unpack that just a tiny bit, you've mentioned Article 5.1, which because it's not the entire picture, I think. Article 5.1, you're talking about a distribution of assets on the liquidation or return of capital. Now, I understand you say that the downside of a liquidation results, you have a preference for the preference shareholders to the return of assets on a liquidation, which puts them ahead of the ordinary shareholders if there's a surplus. So to that extent, they have downside protection, or a downside advantage, shall we say, over the ordinary shareholders. That Article 5.1 is also relevant, though, to an exit provision in Article 6.
Yes.
So that's not so much downside protection, is it? What I'd be interested in understanding is how you see the rights attaching to, because the only rights that are different between the ordinary and the prefs are those rights in 5.1, as I understand it.
Well, exactly. Now, I'm just going to move on to address that, because that is the distinct oddity.
Yes, but sorry, when you said the upside protection is given by the ability to serve a notice under 9.1, converting your preference to ordinary shares, I'd quite like you to unpack the scenarios that you say would give rise to a preference shareholder exercising that option.
Well, the circumstances purely in terms of return are likely to be where the equity value of the shares outstrips the benefit from the 8% return on the investment. So where, for example, the company in a few years has gone up in value by more than 8% compounded over 3 years, then the ordinary shares might conceivably be worth more than the priority return, assuming that you're selling the company at a significantly higher value. And that's been the tipping point, is, as my friend says, it's not necessarily easy to identify. But what is clear is that there is a figure set beyond the tipping point in the bargain at £900 million valuation, at which point as you Lordship pointed out, the priority and cumulative protection, the extra rights, fall by the wayside because you go above the 900 million.
Well, but I'm sorry. Okay, liquidation. There's a preferential return up to of 8% cumulative on the. I think it's the subscribed amount, isn't it?
Yes, including the premium.
Including the premium. There's then an exit provision which talks about a share sale. So if there's a sale of the shares in the company, which is defined as a it's a sale of the controlling interest.
Yep.
Then there has to be compliance with Article 5.
Yes.
So, in a sense, the equation for the preference shareholders in that scenario is to look at the value of attributed to the company to buy the company or buy whatever proportion of the shares are being purchased. And if it's more than the preference return, the preferred return under 5.1,
yes,
you would expect them to serve the notice under 9.1.
yes,
So we're immediately getting sort of bands of protection. So liquidation, one protection, you keep your preference shares because you get ahead of the ordinaries. Or up until a certain point, and then it's in the interest of the preference shareholders to serve a 9.1 notice.
that's exactly the same.
And then you get to the qualifying IPO level, which is the very high level, because I mean 900 million is a pretty chunky company.
Yeah.
And that's far in excess of
Yes.
8% on what was invested.
Yes.
So almost invariably, you would think they would be interested in sharing in that significant upside by serving a 9.1 notice in a qualifying IPO situation, which is why, in fact, the qualifying IPO is a triggering event. It doesn't actually require the 9.1 notice. It actually is a
and that's
automatic.
In the cap on the 8% ceasing once you reach that level as well.
Yeah. Right. Okay. Yep. So you say that, okay, so the difference in rights constituted by 5.1 serves a purpose at a number of different levels.
Yes. And it means that you have the protection, we say, of sticking rather than twisting. You can stay with your minimum 8% return with priority in whichever scenario, unless you're in such a bonanza territory that you would be crazy to do so in the 900 million, or for whatever reason you have the right to do so if it seems, having done the maths, that you're better off with an equity percentage rather than a pure return. As well, in sense, you effectively you instead whether your equity outstrips your loan, you can cash it.
Yeah. Well, you probably,
Mr. Collingwood, I'm sure I'm the only person in court who doesn't understand this, but in what circumstances in this company is it more advantageous to be an ordinary shareholder than a Series A preference shareholder, given that the definition of equity shares seems to be all the shares, and so, have I got this wrong, the entitlement to dividends is the same, and apart from the preferred return, but the entitlement to dividends as such is the same, and the right to vote is the same. What's the advantage of being an ordinary shareholder?
Well, the advantage of converting would purely be if, say, on top of my head I can't do the maths, but say if your preferred return amounted to £50 million, having invested £40 million, and the company is worth such that your whatever 12% or whatever it is of the shares you hold is worth more than £50 million, then there is a financial incentive for you to convert in the sale rather than take your preferred return as a priority because it's a pure financial, effectively payment of a loan. Instead, if the company is worth however many hundreds of millions of pounds it would be to make it worthwhile, you can convert to the ordinary shares and in that sale be paid as an ordinary shareholder your 12% or whatever. So at some point, this is my friend refers to the tipping point, at some point your loan return becomes worth less, potentially, if the company is very successful, than the value of what your shares would be if you took purely equity instead of the what I call the downside protection, the minimum return of the 8%.
Yes, sorry, I can see why it took me such a long time to get there, and apologies for that. Preferred return doesn't mean return in the sense of 8% a year. It means return of sale value on a sale as a one-off.
So it means 8% per year compounded on your investment. So
Yes.
effectively, it doesn't mean you have effectively a loan with an 8% compounding interest, and you were paid as priority, you get that money paid to you. But at some point, the potential equity you would have if your shares were ordinary shares as opposed to preference shares, that value would increase above the successful outcome, increase above what you would simply get for your 8% compounded.
But my lord is right that the occasion on which you would look at that is when there is either a liquidation
exactly
or
so.
a share sale.
Yes.
Or something
Yes.
else, yeah.
Yes, exactly so. And that was the point I was going to come on to.
Yeah, but just to complete this discussion, as I understand it, therefore, you're not differing from Mr. Thornton in this sense that the preference rights are effectively convertible debt. I mean, it's economically, as you were just saying, it's a loan at 8%, compounded annually, as you said. But it's convertible to equity in effect if the value of the company makes it worthwhile.
Yes, that's certainly one way of looking at it. Yes.
Yeah.
But the point is, we have the downside protection of the 8% cumulative return, and as in those interchanges with lordships we've just been identifying, the only different right is the preferred return, and that arises on a liquidation or exit, where that becomes significant. So there's no point in the preference shareholders or in having preference shares if the ordinary shareholders can simply take away the only distinguishing benefit at their whim. The whole structure is absurd because it only matters in circumstances where the ordinary shareholders can see it's to their advantage to enforce a conversion and can do so without any protection, say my friend says, for the preference shareholder. So we say that's absurd. What's the point in having a preference share? You might as well have an ordinary share. Whatever happens, the ordinary shareholders will ensure that you only have the same as them. If it's bonanza time, then it makes sense, or you're caught by 900 million. If it's disadvantageous, they're going to convert. So why have a separate share structure when the preferred return is never going to have any true commercial meaning? Because it's going to be taken away through, my own friend says, an exercise of the right under Article 9.2a. Clue, we say, is in the word preferred. And in my own friend's realm, there is no preferred return. We say the purpose of Article 10.1 is precisely to protect those differentiating rights. And that's precisely what my own friend says Article 9.2a can do away with. And it doesn't make any sense. And we say, as I say, commercially absurd that you have a structure where the only rights are lost at the whim of those with a financial interest and at the point in which they have a financial interest in removing them. Now, I've realised some points obviously been dealt with already in questions with my own friend, so I'll try and take some matters relatively lightly. I think your lordships have on board my points about a class of shares being defined by the rights attached to them as opposed to the designation of the shares, and that there is provision for redesignation under the Companies Acts, and also equally that there is no definition of conversion. And therefore one is looking to the construction of the articles in terms of what conversion means, and also in my submission what Article 10.1 that means too.
Well, wait a minute. I'm not sure the two are comparable. I understand that there's no definition of the Companies Act of conversion, so one has to look at the articles and just with a bit of background of what a share is and to understand what it means. If it's relevant to understand exactly what conversion means, you can see the before. I think we discovered this morning. You can see the before and the after. So quite whether you know what goes on inside the black box marked conversion may not matter. May not. But when you start talking about variation or application of rights in a document such as this, you may have to bring on board some learning derived from company law authorities or by analogy or some principle. I mean, you're not simply confined to an interpretation of a document. I mean, there's some...
Well, I accept that to that extent. But in terms of the interrelation of Article 9.2a and Article 10.1 in my submission, that is a matter of looking.
Yeah, which was essentially what I was asking Mr. Thornton at the start.
Yes,
you
so
know.
I've summarised that probably, but I thought that's where the starting point was. So far as I recognise that perhaps Your Lordships think that swap or exchange doesn't matter. Literally, Your Lordship just mentioned that, but to the extent that it does matter, in my submission, obviously we say, well, two key points. One is the commercial reality of the situation and the conversion, and that's that 1 minute rights are attached to the shares held by Ventura and Sumitomo, and those form a class of shares as a result of those rights. And during that conversion process, the black box, those rights are lost and no longer held by those shares. So in pure commercial reality, we say, that is a variation or abrogation of rights because those rights have been lost through the black box.
I mean, they have been lost by the holders of the shares to which they previously attached and now no longer attach. Have the rights attached to a class of shares been... I mean, I just want you to slightly unpick that because 10.1, if we're actually looking at it, 10.1 talks about where the share capital is divided into different classes of shares. Well, we know that is defined by reference to the rights. The special rights attached to any class may only be varied or abrogated with the consent in writing. You're going to come on doubtless to Mr. Thornton's point that this isn't a variation or abrogation because you're actually just performing, you know, the rights, if you like. But your submission just started out by saying, well, it's the shareholders for the time being of the shares in that class who have lost their rights. In other words, they previously had rights and now and afterwards they don't. But is it the holders of shares that have...
Sorry if I said that. That was not my submission. My submission is that the shares held by those shareholders have lost those rights. And my submission, this is where perhaps the swap or exchange does have some relevance in the black box. In my submission, the shares are the shares. And 1 minute they have rights attached to them, and the next minute they no longer have rights attached to them. But it's the rights that are attached to the shares is the relevant aspect for defining the class. That's how the class is originally defined. And then that class loses those rights through the black box, and as a result of that, they end up in the same class as ordinary shareholders. But in my submission, that is the loss of rights to those shares, which form the class by the definition of them. They are a class by reason of having the rights attached to them. And that's why, on my second point, in terms of the construction of the articles and how one approaches it, I make so much of the stand, I use the words automatically, and stand converted in Article 9.2 and 9.5. I don't know if it's worth turning back. But that's at tab 22, page 329 of the core bundle. So in 9.2, we have all Series A shares shall automatically convert into ordinary shares. So that, my submission, I mean, again, there was some interchanges between my learned friend and the bench. in my submission, all these points about returning the share certificates and changing the share register are neither here nor there. That's the other end of the black box. What matters is what's in the black box. It's automatic.
Do you dissent from the proposition that automatically is elaborated on in 9.5? That tells you what the automaticity consists of.
No, indeed, indeed, my Lord, I rely on 9.5 because in my submission that language is in keeping with a redesignation of the shares as opposed to some form of exchange or swap, because it's automatic on the conversion date, which is the date of the notice. The relevant Series A shares shall, without further authority as contained in these articles, stand converted into ordinary shares. So in my submission, that is simply taking place sits more happily with a redesignation of the shares, simply changing.
I can understand that, but why does that necessarily help you? I take your point that you can say that's more accurately reflected as being a redesignation than an actual swap or exchange. But why does that help you? I mean, it could be said that works against you, because what that's showing is that it is an entirely automatic process, and that supports the proposition that what's being done here is a performance of the terms of the articles rather than any loss of rights.
Well, it's to meet this idea that somehow there is an exchange or swap of securities. So somehow rights aren't being taken away from shares, but you're just getting different shares. So it's to meet that point I rely on this. So by being redesignation and stand converted, it's the same shares but without the rights, and that then dovetails with the fact that they are then said the ordinary shares resulting from that.
If a share is a bundle of rights, what you've just said is a contradiction in terms. If the rights are different, it can't be the same share because a share is a set of rights.
Well, so that it's happening to those. Well, but it's happening to those that bundle of rights, rather than those bundle of rights being handed back and you being given a different bundle of rights as a separate transaction.
But we're all agreed that the piece of paper doesn't matter. A piece of paper is just evidence. So let's start back from square one. I thought you were agreeing that a share in law is a set of rights.
Well, yes.
Right.
The concept of having rights attached to a set of rights, obviously, is perhaps an interesting one.
Yes.
Well,
Tackling.
I mean, you can be. I was wondering about this in the same way as my lord was. I mean, the conventional conceptualization of a share as a bundle of rights sounds very good, and it's helpful, but actually it hasn't got as far as the drafter of the Companies Act 2006 in one respect, because in section 629, headed classes of shares, it says, for the purposes of the Companies Act, shares are of one class if the rights attached to them are in all respects uniform. So that the drafter of the Companies Act, at least in that respect, seems to hypothesize something to its rights attach rather than just an amalgamation of rights. So, I mean, we are getting into a very fine conceptual distinction here, but at least in Companies Act terms, there is a concept of rights attaching to a share.
Well, yes. So that's why I say this is more in the terms of redesignation of the share, in that abstract concept, than some form of swap of one type of share.
Although redesignation is not itself defined, is it, in the Companies Act?
No, but it is recognised that it might, and it clearly refers to the name, effectively the name of the shares.
The only thing in the Companies Act, I think, which is in the bundle certainly, is if you redesignate your shares, you have to make a relevant filing, but it doesn't help tell you what a redesignation is.
No. But in my submission, the natural reading of that, for the purposes of today, is simply to the name of those shares and then the designation of them as a particular share, A share, B share, C share, or what have you. And so that's the natural reading of that. And one is, to an extent, perhaps in this context, the description of shares, as I think my Lord Justice Snowden is suggesting, is inapt in terms of it doesn't sit very happily with section 629 and the concept of class rights, meaning the whole concept of rights being attached to a designated interest in the company, for want of a better expression. But that's why I say Article 9.5 is more supportive of a redesignation, simply a change of the name, rather than some form of return of securities, fresh issue of securities, transfer of securities, or swap transaction, as my learned friend relies on in his skeleton, in order to avoid the concept that somehow the rights attaching to the particular shares have been abrogated. So my point is 9.5 tends to, for this reason, support a redesignation, which simply means a change of designation, such that 1 minute the shares.
But it's sorry to interrupt. I mean, I think everybody agrees that labels don't matter, and therefore a change of labels doesn't matter either. But the whole point of your case is that this isn't just a change of labels. On the contrary, it has a substantive effect.
But the point is exactly that, that by the change of label, the rights are taken away and abrogated, rather than
the special rights
special rights.
in the phraseology of 10.1.
Yes.
Question is whether the special rights attached to the preference shares have been varied or abrogated by what's happened.
And obviously it's only the special rights that are taken away by the redesignation, since they then become ordinary shares with the same, in all other respects, ranking pari passu with existing issued ordinary shares. So it's that by that redesignation process, 1 minute, it is acceptable to view it in terms of 1 minute, those shares have rights attached to them, and then in this automatic stand converted, then those shares no longer have those rights attached to them. And that, we say, is an abrogation of shares within the meaning of Article 10.1. And that's even if it is as provided here. And the friend says, in performance of whatever it may be, it's still, in my submission, it still amounts to an abrogation of those rights, because 1 minute they're there, and the next minute they're not.
And you say there's no cancellation or issue of shares.
Yes.
Yeah, I mean, Mr. Thornton, I think, studiously avoided using those two expressions, rather surrender. I think he used surrender and grant.
Yes.
But which are not Companies Act concepts.
Yes.
But cancellation or issue of shares are. But there's no mention of that in this concept of conversion.
No.
So you say it's notionally, quote, the same share.
Exactly the same.
Differently designated with different rights.
Yes.
Yeah.
And although it's perhaps not a point of particular moment, interestingly, on the covering letter with the notice of conversion, explained that the register of members have been updated to enter Ventura as the holder of converted Series A shares, whatever that may mean. So my submission on that aspect, there's no, it's not right to think of matters in terms of a swap or exchange. It's simply the same shares.
You said that expression a couple of times, and I just didn't get this. Something or exchange?
Swap or exchange. Sorry.
Swap or exchange.
Not swap or exchange. So I'm just finishing. That's what I had to say on that. Sorry. Yep. So moving on to performance and enjoyment of rights. So again, I make the point that as a matter of commercial reality, our case, just been explaining, is that there is a loss of the rights. and that's an abrogation of those rights. So in my submission, my learned friend assumes what he seeks to prove by saying that there's no variation involved. It's purely a matter of performance of Article 9.2a. And he does so ignoring the context in terms of the other articles, the commercialities and the bargain between the parties. Now I accept, the Million Friend didn't take you to the authorities, I accept the distinction between enjoyment of rights and an act affecting rights. And that the Million Friend referred to the White and Bristol case and the John Smith case. But obviously in both those cases, the rights remained identical. The rights attached to the shares remained identical. And obviously here we have a very clear difference that the rights are lost. The shares no longer have the rights attached to them.
So cases where 10.2, I mean, there's a number of things you can do. For example, you can issue shares ranking ahead of you. Sorry, a company can issue shares ranking ahead of you as a preference shareholder, which affects the commercial enjoyment of your rights, value of your rights, because it puts somebody ahead of you in the queue, which is normally said not to constitute a variation of rights. And often you see articles saying, actually that shall be deemed to be a variation of rights to get over that line of cases. Curiously, this set of articles doesn't do that. In fact, if anything, it says, you can issue shares ranking ahead of the preference shareholders. And that doesn't trigger 10.1.
No.
Do you have any idea why that would be?
Why that doesn't trigger 10.1?
No. I mean, why go to the trouble of specifying in 10.2?
The only obvious explanation is because 10.1 is supposed to be so all-encompassing that there would be concern that otherwise it would be thought that that 10.2 might otherwise be caught by it.
Well, not if you know your company law.
But I mean, it's to allow for further rounds of investment in the future, and perhaps to make it clear for those who don't know their company law, and who might otherwise misunderstand Article 10.1 in that context, to ensure that they understand that is the nature of that bargain.
What majority would the creation of a new class of shares require? Is it 75% of the whole voting population?
There may also be restrictions under the shareholders' agreement, but obviously that wouldn't be on the articles. But
Yeah, but otherwise it's just a straightforward alteration of the articles by 75% majority of people voting.
yes, as in fact, of course, has happened, as Melanie pointed out, in the creation of a new Series B preference shares,
Yes.
albeit without Article 9.2a. But other than that, in my submission, I don't think there's anything I can refer to as to explain why 10.2 is set out. I don't think either myself or my friend sought to make anything of that.
No, just checking.
Then moving on to the other cases my own friend relies on, if I can call them the sorting cases. Now, of course, they all involve the cancellation of shares as a result of reduction in capital and payment out to the preferred shareholders at the agreed rate in priority to ordinary shareholders. So the rationale is that the company is simply paying out on the agreed terms. And then my little friend took you to House of Fraser. If I can take you back, it's tab 24 of the Authorities Bible. Page 102. And my friends, to page, bottom of page 107, then at page 108. So this is just to make good this point. So it's just below, just above G, the proposed reduction of capital involves an extinction of the preferred shares in strict accordance with the contract embodied in the Articles of Association, to which the holders of the preferred shares were party. One of the rights attached to those shares was the right to a return of capital in priority to other shareholders, where any capital was appropriately to be returned as being in excess of the company's needs. That right was not being affected, modified, dealt with or abrogated, but was being given effect to. And then over the page, essentially after explaining, I think it's the Article 4BC referred to, just below little a, the reduction of capital now proposed to be made gives effect to that right. This necessarily involves, of course, that all other rights attached to the shares will come to an end, but that is something to which the holders of the shares must be taken to have agreed as a necessary consequence of their right to prior repayment receiving effect. Upon no view of the matter can it be said that as a result, any of the special rights attached to the shares has been modified, commuted, affected, or dealt with within the meaning of Article 12. These words all contemplate that after the relevant transaction, the shareholders in question will continue to possess some rights, albeit of a different nature from those which they possessed before the transaction. The proposal for reduction of capital involves the complete cancellation of the shares. The part of the ratio was there's no variation because you don't still hold shares with different rights. You're having performance of one of your rights, and the whole point of that performance is that you were then have your shares cancelled. You're not left in the company holding different rights to the ones that you bargained for. Now, in our case, of course, we say the rights are simply lost, and the class of shares has no preferred rights after the conversion, but the shares are retained, and so the preferred shareholders are left locked in with no special rights in a completely different scenario. And that was the ground upon which the judge, in his judgment, in his post-draft additions when the additional authorities were filed with him, he distinguished it on that ground, because the preferred shareholders get the preferred return. They get what they bargained for. Now, in our case, we don't get the preferred return. The preferred return is taken away and extinguished.
I mean, are there 2 points that Lord Keith is making? I mean, the first point is performance, and the second point is it's only a variation or modification, commutation affected or dealt with if there's something left. I mean, they're not quite the same point, are they?
No, well, but it's in those circumstances that he will, because the performance involves there being no rights afterwards. Obviously, that's why there's no variation, because the shareholders don't hold anything off.
But if you had a performance which, I mean, if you had a performance which did leave something afterwards, and I can't quite envisage it at the moment, but if you had rights, special rights attached to a share, and the performance left some other rights afterwards, I think on his hypothesis, you still wouldn't have a variation of rights, you just have performance.
Perhaps it's because it's quite difficult to quite imagine what that scenario might be off the top of my head. But all of those cases, in any event, do involve a situation of reduction of capital, and where the shareholders no longer hold any shares. So, in my submission, to extend it, it's not appropriate to do so, because it makes sense in those circumstances that you don't say there's a variation, because the rights have been completely fulfilled, and that's what you bargained for was your priority at the preferred rate. Whereas what we have here is something very difficult. I mean, in my submission, it's very difficult to describe it as performance of a right in any event, or even to regard it the right under Article 9.2a is somehow a right attaching to the shares that's being performed. The point in those cases...
Hang on. Mr. Thornton says that 9.2a is a right to which the shares are subject. As it happens, it's a right in the investor majority. In a sense, your rights are subject to that condition, that possibility, and all that happened was that which 9.2a said should happen in certain circumstances.
But in those circumstances, in my submission, that's not the performance of a right attaching to the shares in the same way as the 14 cases.
But the investor majority were performing a right which, as far as they were concerned, they had in relation to those shares, namely to give a conversion notice.
Yes, but in my submission, that to describe that, well, the 14 cases are involved with fulfilling the rights bargained for, performing the rights bargained for which are attached to the shares. This is, it can't in my submission be put in the same description, because it's not under any ordinary understanding of the language. It can't be described as a right attaching to the shares. Now, perhaps it's a limitation, but if it's a limitation upon the rights, in my submission, that doesn't take it outside in terms of performing the rights, and therefore there's a variation of the rights.
So this right,
not performing it.
The right of your clients to give a notice in respect to their own shares under 9.1 is a right attaching to the shares.
Yes.
But the right for the investor majority to give a notice under 9.2a to achieve conversion of the shares is not a right attaching to the shares.
No, as your lordship says, it's a limitation. Not a right. And that's because it's not a performance of rights in my submission, it's a deprivation of rights.
What do you say to the argument that in effect 9.1 and 9.2a are quid pro quo?
Well, that then comes into the commercial absurdity in my submission of, as I started out in my submissions, the downside protection and the fact that if 9.2a is, as my learned friend says, then there is no downside protection and there is no real commercial benefit in the preferred return because it can be taken away. So there's no quid pro quo, there's no mirror. It's just that what one would expect in terms of the downside protection doesn't exist, and one might as well simply have an ordinary share. So there's no sort of quid pro quo benefit of you get your to convert at the top and we can make you convert at the bottom. That's not how preferred shares work. The whole point is to have protection for the minimum protection on the downside in the form of the cumulative preferred return, cumulative dividend, and then potentially, if there is the option to go for upside, to have the ability to convert in the appropriate circumstances. But it's in my submission is there's no sort of balance to the bargain that way. It's all one-sided because it basically means that the preferred shareholders might as well simply start with ordinary shares.
Okay, we're beginning to confuse two things, aren't we? Mr. Thornton says, look at 9.2a. So far as the company is concerned, his clients, the person you've sued, all the company is doing that which 9.2a requires it to do, namely acknowledge that because of the recipient, that it was the recipient of a notice in writing from the investor majority, the company must acknowledge that the A or Series A shares have been converted into ordinary shares. So he says from the company's point of view, it is performance. It's performance of a right relating to their shares, which is affected by, in a sense, it affects your clients as the holder of the shares, but it's triggered by a notice given by the other shareholders in accordance with the article. So he just says it's performance, from the company's perspective. One set of shareholders has done something and it's had an effect upon the others, but it's performance. So he says that's it. You don't need to go any further. In order to go further, you have to write something into 9.2a, don't you?
Well, the inevitable response, although I realise it's a different point, is to say obviously that they have the protection under Article 10.1, and that is inconsistent with, or at least the notice is invalid, and therefore the company isn't.
Yeah. So as I was putting to Mr. Thornton, your proposition at its core is that it was an invalid notice.
Yes.
And as I understand it, your argument is it's an invalid notice because it doesn't comply with 10.1. The rejoinder is it doesn't have to comply with 10.1 because it's no cross-reference, to which you say, but hold on, there are two provisions in the same set of articles. They've both got to be given effect to, and the only way to give effect to both of them is by taking it that 9.2a means subject to 10.1.
Well, yes. And that's as a matter of construction simply in my submission, because 10.1 is so broad and in its drafting and event, one would imagine that precisely what it was designed to protect. And secondly, because of the commercial absurdity of the other side, which is the idea that somehow the ordinary shareholders can at any time, as they see fit in their interests, derive the preferred shareholders of the entirety of the preference, or the differentiation.
But if they only reduced it from 8% to 1%, they would need consent.
Yes. Yes. The other absurdity, of course, exactly as my Lord Justice points out, being that the absurdity or that they can't adjust aspects of the rights, but apparently they can completely wipe them out in one fell swoop with only a majority.
Yeah, can I just ask, what in your submission is the right route to the result for which you contend? Because I think we've arrived at a position where it's common ground that at the end of the day this is an issue of interpretation of the articles. There's no independent statutory provision that bears upon the matter. Everybody agrees that the articles have to be interpreted as a whole. The judge, as I understand it, really thought that it was, although it was partly a question of interpretation, when it came to the question of the tension, as he put it, between the two articles, he thought the right way forward was an implication of a term. Do you support that approach? Because I wonder if there's another way of looking at it, which is it's not really an implied term in the conventional sense. This is more a question of reconciliation of conflicting terms, or terms that may conflict in certain particular circumstances, such as those that we have here.
Well, at trial, we put it in a number of ways, as one might expect.
Yes.
That was one of them. The two that found favour, that one didn't. I think I think partly because of the manner in which these issues were addressed in submissions and also in the judgment, in terms of treating them as discrete. When in fact this actually really comes down to a matter of construction, I think as the Lordship is saying, rather than simply trying to work out whether there's a conversion or abrogation, whether one can look at 9.2a in isolation initially and then look at the broader picture afterwards. But in any event, the learned judge accepted the corrective construction Britvic approach and the implied term approach in the alternative, and we argued the pure, you just look at the terms and this is how they work together approach as well.
Yeah.
And obviously, my submission at the time was all roads lead to Rome, and he accepted that on the two, but it didn't on the third. If and insofar as I would need to put in that as a further reason, I don't think fairly I have, but obviously I would wish to do so. But it is that inconsistency between the two. And for them both to work and have business efficacy, in my submission, 9.2a has to give.
But that begins to sound like an implied term.
Well, there's in terms of the construction of inconsistent terms, well, the construction of the terms, the fact there simply is that 9.2a gives a power for something to happen automatically, but for the notice to be valid at the beginning, it would have to comply with Article 10.1, and therefore Article 10.1 applies first. Once you've met Article 10.1, then you can serve a valid notice under Article 9.2a, and the matter then simply goes through as it is. But you don't get to Article 9.2a unless you have first complied with Article 10.1, because the notice isn't valid.
There used to be an old rule of construction, which I think still exists, or although I think it's nowadays reckoned to be an absolute measure of desperation if all else fails, which is that if you have a contract with two inconsistent clauses, the later clause trumps the earlier clause.
That sounds very compelling. Well, that's how, in my submission, that was the starting point in my submissions at trial, was simply that in terms of how these two work together, you don't get into the territory of 9.2a until you've complied with the rights. In the same way that if there was an attempt to amend the articles by special resolution in a way that varied the rights, then Article 10.1 would apply in the same way. It wouldn't say anywhere, oh, by the way, you can't amend the articles by special resolution unless you've complied with Article 10.1 first. But the point being, where 9.2a does involve rights attached 1 minute, rights not attached to the next, then if you haven't complied with Article 10.1 for the purposes of exercising that notice, then it's not valid and Article 9.2a does not apply.
So it's just right, you say that you don't need to, in fact, do either of two things, which the judge, I think, did. One is he certainly did one of them, which was notionally to write some words into 9.2a, which sounds remarkably like implication of terms. And you would also don't need to assume that there's been a drafting error, which needs correction by constructive,
Yeah.
what do they call it?
Corrective construction.
Corrective construction.
The Britvic approach.
Yeah.
Well, if one takes, I think the problem is this: if one takes Article 9.2a in isolation, then there's a drafting error because it doesn't say anything about giving way to Article 10.1, and that's absurd.
Right,
because it's absurd that.
But you don't take it in isolation; you take it in.
If you take it in the whole scheme of things, it reaches the same result, which is that you have to comply with Article 10.1 first in any event because it applies regardless.
So the true meaning of 9.2a on that approach is that it's subject to,
which is the same as the corrective. Same as the corrective. I mean, it's a difficult. It feels like a very binary situation, but effectively they're saying the same thing, just depending on exactly how one construes Article 9.2a, which is that if it's not subject to 10.1, then it certainly ought to be. because the alternative is the absurdity of the trapdoor on the rights and preferred return having no real commercial meaning.
Sorry, I was writing that down, and now I've just finished writing it down. I'm not sure I understand it. You say the alternative has no commercial meaning?
The alternative, if 9 point is commercially absurd, and the preferred return has no real commercial meaning.
I mean, 10.1 has purpose in other respects. For example, reducing the coupon, the notional coupon. That would be, Mr. Thornton accepts, a variation of the right attached to the class of Series A shares.
The preferred return would have no purpose in that
Yeah.
we can go at any point in time.
Yeah.
Taken away.
And the absurdity is that you need that class consent for every reduction down to 0.00001. But if you take it down to 0 just by taking it out completely,
Yes.
you can do it by an ordinary majority, in fact, of the...
Yes.
But it's an ordinary majority of the...
Well, effectively the ordinary shareholder, but I mean, because it would include us.
Yes,
but we're
still
minimal
wants to-
compared to the 168,000
But
ordinary shareholders.
you use the expression commercial absurdity, which I jeer about slightly because courts are not judges of commercial bargains. But your argument is it's logically absurd. It's just simply illogical
Yes.
to say you require consent of 75% of the affected class to get it down in steps, as my lord postulates, but not to do it all at once.
Yes, and also absurd to have a preferred right, which is contrary to the interests of the person that at any point can remove it.
Yeah.
Simply to have that, and that would be the only distinguishing feature, really, between terms of rights, which makes your class.
And for this purpose, as I understand it, doesn't matter whether the total value of the company is, or of the preference shares is 4 million, 40 million, or 400 million, or 4 billion. It's simply that you say the structure of the articles suggests that the draftsman provided for a class of shares with preferential rights, and there is a reason for that, and if the preferential rights can just be obliterated by the non-professional shareholders the day after the bargain is struck, that is absurd, whatever the value of the company.
Yes, and well, the one uses the word logical commercial. I mean commercial in the sense of logic, as opposed to commercial in the sense of value, although it would have value. I don't know if you also want me to unpack any further on, or to address Britvic any further, or any of those aspects. Is there anything further I can be of assistance on?
There is the question of your cross appeal, of course, if you're still minded to move that.
Should we want to move that now before my friend replies, or should I do it after he's replied?
We'll just rise for a moment. Mr. Collingwood, let's go straight on to the cross appeal.
So the cross appeal is only relevant if your lordships hold in favour of the company on the B grounds, the construction,
Yes.
but against it on the E grounds, either is a variation or abrogation of class rights, but Article 10.1, for whatever reason, yields to Article 9.2a. And I seek permission to cross appeal on the claim under Section 633 of the Companies Act, and for variation of the order to effectively provide that instead of the a variation being invalid, it's cancelled, having been. My submission, the judge was correct in holding that Section 633 applies to the variation of class rights under a provision in the Articles, and correct in holding that there is a case of prejudice, but he made certain errors set out at paragraph 4 of my grounds of appeal, which are at tab 6 of the core bundle, page 61, and paragraph 79 of my sellers note. So the first, so it's page 61 of tab 6.
Yes.
The, paragraph 4. So the first is at paragraphs 117 and 121, that the impacts and consequences of the variation in respects beyond the Articles, including in particular the respondents' rights under the shareholders' agreement, were irrelevant to consideration of unfairness under Section 633. So effectively, the judge held that he couldn't look beyond the actual changes concerning the Articles, so he couldn't look to any other extraneous matters. Then, in the second, that the rights enjoyed by the respondents as holders of a particular class of shares under the shareholders' agreement as amended, so the shareholders' agreement rights couldn't constitute rights attached to the shares for the purposes of Section 633, because those rights under the shareholders' agreement were also lost. Then that there was no unfairness in the relevant shareholders exercising their hypothetical power under Article 9.2a to cause a variation and or abrogation of class rights in order to improve their own financial position at the expense of Ventura and Sumitomo, and contrary to their interests. And at 120 that the conversion, its consequences were simply part of the bargain between the parties, and then implicitly there was no impropriety in the purpose the ordinary shareholders exercising their hypothetical power. Now, actually, before I go into the law on Section 623, there are a couple of additional matters to take your lordships to in terms of the documents that weren't relevant for the purposes of construction, but do come into play in my submission for the purposes of fairness under Section 633. And if I could start with the supplemental bundle. At tab 14, page 201, 201. So this is an email from Professor Tumazu, who is one of the directors of the company, on the 18th of December 2020. So this is with a view, it's to the various shareholders in the company. Subject shareholder update, proposed issue of Series A shares led by Ventura Capital to raise up to £15 million. So this is going to the shareholders about the share raise. Dear shareholder, proposed issue of Series A shares led by Ventura Capital to raise up to £15 million. Further to my update, sent you on 23rd November, as promised, I'm writing to you with further details of the investment round which DnaNudge Ltd would like to carry out, and which is being led by Ventura, to raise proceeds for production and manufacture of cartridges and nudge boxes. Those are the two key items that were being produced at the time, in particular used for COVID testing. In order to fulfil our contract with the NHS and expand into the private sector, increase scale, infrastructure, growth in R&D, and corporate development of the consumer and diagnostics business. The investment round will value the company at approximately £420 million, my friend referred earlier, on a fully diluted pre-money basis, and comprise, and there's the reference to two investments, initial investment 10 million and further investment 40 million. And then the next section, a new class of Series A preferred shares, the Series A shares, will be created and issued to Ventura and any other investors at a subscription price of £2,350 per Series A share. The Series A shares will have a customary 1x non-participatory liquidation preference, which ranks in priority to the other classes of shares, i.e. that Ventura will receive their original subscription price paid per share ahead of the other classes of shares, and a preferred dividend return on liquidation of 8% per annum, compounding annually, which will be cancelled once the company raises additional equity investment of at least £10 million at a pre-money valuation of at least £900 million. But otherwise, the Series A shares will rank equally with the other classes of ordinary shares. As part of the investment round, Ventura will receive the right to put any or all of its Series A shares to the company for purchase if an IPO or other liquidity event has not occurred within 3 years. Ventura will receive a warrant to subscribe for additional Series A shares at the same subscription price of £2,350 per Series A share for an amount equal to 20% of the total amount invested by it. The existing shareholders' agreement relating to the company, the SHA, will be varied to add references to Ventura and the new Series A shares, to provide information rights to Ventura, to include the personal put option right to be given to Ventura, to remove the existing preemption rights on transfer of shares, which will be dealt with under the articles, and to provide Ventura with the right to appoint a director and a board observer. New articles of association, which will contain the rights relating to the Series A shares, will be adopted, and the shareholders will be asked to authorise the various documents. Anticipated the initial investment will be complete by 31st December, and my subsequent investment will complete by 19th of February.
Sorry, I don't want to stop you reading, but why are we reading this?
Some of the points that I'm making are as to the unfairness of the variation. So one of the points I rely on in terms of unfairness is that the shareholders agreed to the terms. I'm now going to move on to the shareholders agreement to also put the various other aspects of the shareholders agreement which were impacted by the
this
various.
Isn't the shareholders agreement, though.
No, this isn't. But this is to show that the way that the entitlements, the bargain was described to the shareholders was with the preferred return being the thing that was highlighted as the bargain.
Well, the bargain surely is constituted by the articles and the shareholders agreement.
My lord, yes.
Not this document.
No, it's not. This is why I say it's not relevant to the construction. What it does show is that
why is it relevant to fairness either?
Well, because in my submission, there are occasions where my learned friend says, well, everyone has gone on the bargain on this basis, and the shareholders went in with their eyes open in my submissions to exactly what they were doing, and it was described to them in this fashion.
The point you've got to meet is that when one's looking at fairness or unfairness, more particularly, either under 994, under Section 994, or is there any reason why it should be any different under 633, you start, and absent any equitable considerations of the type Lord Hoffman mentioned in Saldy Harrison and O'Neill and Phillips, you end with that bargain as well. In other words, so you're not saying this is a quasi-partnership, you wouldn't be able to say that. So why do we look to anything other than the terms of the contracts?
Well, in some ways it goes to the intention, the rationale, the behind the ordinary shareholders in the use of the investor majority under Article 9.28, circumstances where it wasn't contemplated.
Well, with the proviso that question mark over whether you should be showing us any of this, would you like to go on to the shareholder?
It was all before the judge. And
yes.
Then, if I can go on to the shareholders agreement.
Just before we do, I just didn't get that last bit. You say this is all relevant to the intention behind how the ordinary shareholders could exercise the rights under Article 9.2a, this is on the postulate they're entitled to exercise the rights under 9.2a in the way that they have done.
But one has to look at the shareholders' agreement. Has a provision that applies for the spirit and intention of the shareholders' agreement. And I wasn't planning on focusing massively on this, but obviously I was using it as a segue into the shareholders' agreement and the spirit and intention of the shareholders' agreement.
Okay. So, what you say that the fact that the shareholders' agreement included a spirit and intention clause makes a difference.
Well, that spirit and intention in my submission is shown by that email. Yes.
But, there's quite a lot of law on the meaning of good faith in agreements like this and spirit and intention, including a rather long, perhaps overly long judgment of this court that I authored last year. We don't have any of that. I mean, if you're going to start, are you going to start saying that the spirit and intention clause in the shareholders' agreement means that the court takes a different approach to 633 than it would ordinarily take? Then you're about to wade into some very deep water.
Well, what I'm going to say is that the learned judge ought to have taken into account the loss of the rights under the shareholders' agreement.
Okay, well, I'll put my marker down.
Yes, no, your marker is well noted.
Right.
Right, where's the shareholders?
It's in the core bundle at tab 19. So this is the shareholders' agreement dated 16th of June 2016. It in fact makes more sense to because obviously this is varied at the point of time of the investment, and so the variation appears at tab 20. Deed of variation, but the deed of variation is varying that shareholders' agreement. And you'll see this is between the shareholders and the company. And under at page 288 at tab 20, we have variation to clause 3.2 of the shareholders' agreement. The new clause with various information rights given to Ventura. And then under 3.3a, we have what's referred to as the put option. If a qualifying IPO as defined in the article does not occur prior to November 19, 2023, such date being the trigger date, Ventura shall have the right to require the company to purchase all or any portion of the Series A shares held by it, and any permitted transferees, and any Ventura co-investors. The put option, and subject to clause 3.3c, the company shall be required to purchase such Series A shares for an aggregate purchase price equal to the preference amount per Series A share. The put option purchase price. So that's the put option, the various details of how that's calculated. Then in G, we have variation to clause 10.1 of the shareholders' agreement. Clause 10.1 of the agreement shall be deleted in its entirety and replaced with the following. 10.1. Ventura, for so long as it, together with its permitted transfers in Ventura co-investor, holds at least 4,255 Series A shares, and each such shareholder holds at least 10% nominal value of the shares in issue from time to time, they have right to board representation. So we have the put option under the shareholders' agreement and the right to board representation. Then if one turns back to the shareholders' agreement, and this is the clause I was just referring to, it's clause 12, so it's tab 19, page 266. Perhaps your Lordship can just read 12.1 to 12.3. So the principal point here is, in my submission, we sought to rely on the loss of the rights under the shareholders' agreement. So I'm not trying to probably, I think, perhaps stray into what your lordship's worried about. It's more the matter that it's the loss of the rights under the shareholders' agreement for the put option and the board representation, which I say that the court ought to have taken into account in all the circumstances under Section 633. So it's not just the loss of the preferred return, it's also the loss of the rights under the shareholders' agreement.
Because the put option only applies to Series A preferred shares and not to ordinary shares.
Yes.
But this is what still you need to meet square on the point. If this is the inevitable consequence of something which the company or the investor majority is entitled to do under the terms of the agreement, how do you escape from the point that it must be fair because it's what you've agreed? I mean, it may prejudice you. In a sense, you would prefer it not to happen, these things, but it's not unfair because it's what you've agreed.
Well, it's unfair.
Which palm tree do you want us to sit under?
Well, not 994. Well, it's unfair in terms of, perhaps we're jumping a couple of hoops to get, I suppose, to the final one. In terms of we're evading whether I can even rely on it at all as part of all of the circumstances and the like, and cutting to the nub. But it is unfair because there's no provision in the shareholders' agreement for the loss of the rights. It's assumed that the Series A shareholders will maintain them. There's no provision for, and the state of the agreement is that it prevails over the articles.
But the postulate that we're in here is that you've lost on the main question, which is that the rights could simply be, that your preference shares could be converted by the giving of a notice.
Yes.
Without going through 10.1.
Yes, but in the sorry.
If they were entitled, if the investor majority are entitled to do that, it follows as night follows day that you no longer hold preference shares and therefore can't exercise any rights which are given by the shareholders' agreement to the preference shareholders.
But the in my submission, the shareholders' agreement provides for the put option right and the board representation right, and nowhere does it contemplate that those rights can be lost or removed, whether through conversion of shares or otherwise. And it provides that the...
Hang on. Wait a minute. 3.3, just looking at the put option. If Ventura no longer has any Series A shares, if it doesn't any longer hold any Series A shares because of the operation of Article 9.2a.
Sorry, can you put me out to...
Sorry, it's 288, page 288. This is the put option. So I just picked the put option, okay? So put option is dependent upon you holding Series A shares because you've got nothing to put otherwise. And if you don't have Series A shares, you've got nothing to put. Therefore, why is it unfair? I mean, it's a necessary consequence of the operation of the articles that you no longer have shares to put.
Well, yes, but in circumstances where the shareholders' agreement takes precedence over the articles and it provides for...
There's no inconsistency. It's not prevailing in the event of an inconsistency. There's no inconsistency. It's just you haven't got any shares to put.
Or perhaps I am starting to say it's in the spirit and intent then.
My impression as a layman in these matters is that if you succeed on the main point, you don't need this. If you don't succeed on the main point, you're in trouble. But that's just a layman's perspective.
I mean, the difficulty with the spirit and intent is that there are authorities, which I did rehearse in that earlier judgment, which sort of effectively say that you don't find the spirit and intent outside the terms of the agreement. You know, it's the spirit and intent as defined by the terms of the agreement. There isn't some sort of mysterious penumbra around the terms of the agreement. So if the terms deprive you of the things that you would have the right to put, such that you can't exercise the put option, it's difficult to see.
Well, I certainly wasn't intending to suggest there was anything outside of the shareholders agreement as such. Purely that the shareholders agreement provides for these additional rights, and that in circumstances where there's nothing that provides for them to be lost. Now, I take your Lordship's point that the way they've been phrased, they are no longer apply and fall away, but that's something that falls under the articles as opposed to under the four corners of the shareholders agreement. So in the spirit and intention of the shareholders agreement, they are the rights that would be therefore specifically provided by variation for Ventura until. And the other third point, I mean, perhaps is worth just dealing with tackling the nettle, avoiding all the sort of technical issues in between, and tackling the unfairness, which is obviously the point that is perhaps the most likely point of issue for me. The other aspect, of course, is the purpose of the use of the Pound Article 9.2a in circumstances where it is affecting class rights of other shareholders. And the express purpose, as stated in the circular, was to nullify the put option.
If they're entitled to do that, because that's the bargain, that's just, they're entitled to do it.
But then in circumstances where they're, perhaps this goes to the absurdity again, in circumstances where they are abrogating class rights.
Yeah, but this is the problem. This whole case, the 633 case, is run on the postulate that they were entitled, the investor majority are entitled to do precisely that which they have done, because that's what you agreed.
As a matter of, yes, in terms of the validity of it. Yes. I accept that. If I might just
Of course, please do.
My Lord's, discretion being the better part of valour. I can see that I'm pushing at a very closed door in terms of which I don't really much see a lot of time.
It's not closed, just might take a bit more
but
ingenuity or muscle to move.
I think that the unfairness is the real issue, and I don't think there's any real benefit to your Lordships of me taking you through my other points on the other aspects when I can't add anything further.
Well, the one thing that you could assist me with is you talked about the SHA containing a provision that it overrides the articles where they're inconsistent. Which is the provision you're?
So that's an article. That was the clause 12. Sorry.
Oh, it was
12.2.
Right.
That's why my Lord Justice Snowden pointed out there's no inconsistency, so that doesn't help.
Yeah. Okay, understood.
So I think in those circumstances, rather than waste Lordship's time with all the other aspects, I simply withdraw the application and stand on my opposition to the appeal, since I'm not going to be able to, I think, add anything further on unfairness, or for your Lordships to rule, if you wish, on the unfairness aspects, but I can't see the benefit of taking you through the other aspects and wasting everybody's time when I can't do anything more on unfairness.
Right. Well, I think it follows, Mr. Thornton, that we'd like to hear you and reply on the appeal, but you need not worry about the permission to cross appeal.
So any questions your lordships had for me? The only point I wanted to just quickly go back to was the House of Fraser case and the suggestion that
Yes.
you could distinguish it on the basis that in House of Fraser and the reduction cases you're essentially performing the bargain. The position in relation to the preference share cases is, as with these preference shares, there was a coupon and there was a right to a preferential payment return of capital. And the reason why those cases were opposed, or the reductions were opposed, not because of the repayment of capital, but the fact that people were being deprived of their dividend. So yes, they got the payment of capital that they get on a winding up, but they were being deprived of their ongoing right to a preferential dividend. So it was sort of, you get your money back, but you lose out on your preferential dividend. And that's no different from the position here, because of course the effect of the conversion is that you lose your special right in the sense of your right to a preferential right on a distribution, but you have removed the glass ceiling to what you might get by way of upside, because the preference shares had a cap on what they might receive. So there's, in my submission...
Sorry, you're going to have to unpack that a little bit. The way that Mr. Collingwood puts it is that the right to a preference, a preferential return, in certain circumstances, namely liquidation or a sale, an exit sale, he says is a flaw, it's a protection, which exists for the benefit of the preference shareholders because it's their minimum.
Yeah.
And if they want to, they can serve a notice under 9.1 to take something else. So, sorry, did I misunderstand? You were talking about a ceiling, I thought.
So in other cases that might be the position, but they didn't have the right here to sit on their preferential right until they decided to change. Their right was part of a bundle of rights where they also conferred upon somebody else the right to take away that preferential right. So it might be in a different situation, a set of preference shares would simply give them that entitlement and not contain the...
But that's the question.
Sorry?
That is the question.
Yes.
What commercially... I mean, it is said commercially, it is absurd to suggest that they would have bargained, notionally, for this right to provide them with a protective floor on terms that it could be taken away by the very people who would benefit from it being taken away the day after it was granted.
But because what they bargained for was a right that was subject to that trapdoor. That's what they bargained for. They didn't bargain for a permanent right to sit on that preferential right. It was always capable of being undermined, just as the ordinary shareholders accepted that it was open to Mr. Collingwood's clients at any stage to jump into the ordinary share.
But they say it's a trapdoor, which is only sprung if 75% of them agree, and that's what makes it a sensible. You know, people don't go stand on trapdoors when somebody who will benefit from pulling the lever has hold of the lever. You know, they say no. There is a protection, which is that 75% of the people affected would have to consent. I mean, that's the very question I think we're here grappling with. Because it doesn't help you just to simply say, well, they contracted for it, because that's just repeating your sort of point that 9.2a is freestanding. Well, it doesn't need to be read together with 10a, sorry, with 10.1, when the very question we are grappling with is, does it?
Yeah, and the point I was making is the ratio of House of Fraser is performance. So the question is what is done in accordance with the bundle of rights that were granted?
Yes.
And what it says is if it's in accordance with the rights, it's no variation or abrogation. If that is a bad deal, that is a bad deal.
Yeah.
But that's the ratio. It's not different because it was a reduction. The underlying principle is, it's not a million miles away from the point you just debated about fairness. Ultimately, the commercial parties agreed a set of rights which are clear and unambiguous on their terms, we say, and the court doesn't if those rights are performed, that's the end of the story. And it's not a distinction here to point to housing phrases. Oh well, it's a reduction, and they were paid off in their entirety. The principle is a much broader one, which is the transaction in accordance with the rights set out in the articles. You don't look to try and reinvent the wheel. There wasn't anything else I think I detected in my learned friend submissions that I
hadn't dealt with.
didn't think there's anything else.
We're very grateful to you. Can I just ask both counsel this? We'll obviously reserve judgment. We're not in a position to give you a result in the next half an hour. It may be that we reach a clear conclusion on the result in the next few days, even if we're extremely unlikely to be able to produce a reasoned judgment in the next few days. Can we be advised by what date do you all need to know the outcome?
I think in terms of, I don't think we can say there's pressing urgency in the sense that it needs to be done in the next week or two. The main reason for seeking expedition was that the put option is exercisable in November. My learned friend still holds a share. So I think that the rest, as much as we'd like it as soon as possible, I can't say to your lordships that we need it before the start of next term.
Yeah, my understanding at that time was that you needed an answer by the end of October. And if I've understood what you've just said, that still holds.
Nothing's changed from when we sought expedition before you.
Mr. Well, it certainly would help the parties, I think, if there were to be certainty, at least as to the result, because obviously there is a transaction currently under negotiation. So whilst the put option was the basis for the expedition, there is a transaction currently in negotiation with a bit of uncertainty, obviously, as to where my clients stand. So the result, if that's possible, would be helpful. But we don't have a particular deadline we can refer to in terms of urgency.
Well, shall we say this, that if we reach a clear conclusion as to the result, we could announce the result and send that to the parties. We could do it on the basis that no order would be drawn up which would preserve the loser's rights to seek to apply to take this further. I'm not encouraging it, just mentioning it. But that might depend on what the result was.
But would
Any
the
thoughts on
result
that?
the result be embargoed as well? Because obviously that might have an impact. No, we can't tell anybody. It may be less use, in all honesty.
Oh, no, it wouldn't be on the basis that you have to keep it secret. That would be pointless. I mean, this court has done this in some cases, that it's announced that the appeal would be dismissed for reasons to be given later, or the appeal will be allowed and a declaration made in the following terms for reasons to be given later. I'm not promising that we would do any of this, but with the vacation about to intervene, it may be that you would prefer to know the outcome if there is one before October.
My understanding is it would be preferable, but we understand the expectation. Well, there's no expectation.
If, as I say, if we do announce the result, then that is not on a confidential basis, or there would be no point. Whether or not we do, when it comes to a formal hand down. Council know all this very well, but the draft judgment is sent out on terms that it's only for the parties and their advisors, not for general dissemination, and it's sent out not for the case to be re-argued, but for typos and factual corrections and all that. You know all that. Thank you both for your very concise and helpful submission.